On its 50th anniversary, we present the story of the Washington State Court of Appeals, Washington's Intermediate Appellate Court. 1969 was a historic and tumultuous year. The Boeing 747 flew its maiden flight. The Cuyahoga River caught fire. Campus unrest blanketed the nation. The United States began withdrawal of troops from Vietnam. 400,000 youth camped for 4 days at the Woodstock Music Festival. The Manson family killed 7 victims in Los Angeles. Man walked on the moon, and the New York Amazing Mets upset the Baltimore Orioles in 5 games in the World Series. And in 1969, the Washington State Court of Appeals was born. 50 years later, the Washington Court of Appeals, the state's intermediate appellate court, still serves its function as the workhorse of the Washington appellate court system. This year, 2019, we celebrate the 50th anniversary of the court.
Ladies and gentlemen, I have been informed that the jury has reached a verdict, so I would ask, would the presiding juror please stand and identify yourself?
Julie O'Rourke.
Ms. O'Rourke, has the jury reached a verdict?
Yes, we have.
Will you please hand the verdict forms to the bailiff?
A trial does not end a case's judicial process. Under American law, a loser has a right to appeal.
In the Superior Court of the State of Washington for
all state judicial systems and the federal judicial system started with one appellate court, the state Supreme Court and the United States Supreme Court. But throughout the 20th century, appellate courts experienced significant increases in workload as a result of population growth, expanded post-conviction and appellate rights in criminal cases, increases in legislation and government regulation, and a societal trend toward resolving social and economic controversies through the legal system. The burgeoning workload resulted in a backlog of appellate cases and a growing lack of confidence in the judicial system.
Supreme Court of the State of Washington is now in session.
By the 1920s, the Washington State Supreme Court, as the only appellate court, was overloaded with work flowing from the superior courts.
Back in the 1930s, a very prominent lawyer, Al Schweppe, who had been a former dean of the University of Washington Law School, made a speech. I think at that time he was president of the State Bar Association, that we need an intermediate court of appeals in the state of Washington because the Supreme Court is just has such a load that they're having difficulty keeping up. That was in the 1930s.
In 1967, the Washington State Legislature sent to the Washington citizenry a proposal to establish the Washington State Court of Appeals. With the proposal, Washington would join many other states in establishing an intermediate appellate court in order to reduce the workload of the state Supreme Court. The United States added its intermediate appellate court, the United States Circuit Court of Appeals, in 1891. On November 5, 1968, Washington voters approved a state constitutional amendment that authorized the State Court of Appeals. Governor Dan Evans made the initial appointments to the court, with all judges facing election at the general election of 1970.
And I remember that one pretty clearly because Bill Gisberg, who was chairman of the Judiciary Committee in the Senate, and Wes Ullman, a young lawyer from Seattle who was also a senator, came down to see me. And Bill Gisberg said, Governor, you know, how do you intend to make appointments on the Court of Appeals? He said, you know, we don't have to make them happen right away. We could let them all go to the first election, but I'd prefer not to do that. And he was just asking how I would do it. And I said, well, Bill, probably I'll appoint more who have a Republican background than Democrat, but what I will really do is pay attention to the Bar Association, their recommendations, and Bill Gisberg said, well, that's good enough for me. He got up to leave, and Wes Ullman said, well, how many Democrats and how many Republicans? And Bill said, get out of here. So that's the way it went. They allowed the governor to make the first 12 appointments, and we were pretty careful on that. We had plenty of applicants, some of them superb, some of them not so superb, but we made the appointments. They were all received pretty well, and in the first election, which had to occur fairly immediately, not one of the 12 was even opposed, so that made me feel pretty good.
Judge Jerome Ferris, one of the first judges of the Washington State Court of Appeals, serves today as a judge on the United States Ninth Circuit Court of Appeals.
Most of us met for the first time when we were gathered to be appointed to this court, and yet we became very close friends. It was almost remarkable how close we came and how much we cared about each other.
Not too long after it was formed, the Division II of the Court of Appeals had their courtroom at the Tacoma Mall office building. Justice Pearson and Harold Petrie, who was a good friend of mine, a wonderful man, World War II veteran, they told me they wanted to make sure that Division II had the first published decision of the Court of Appeals. And the inaugural ceremony, swearing-in ceremony, was on September 8th, 1969. And the Division II of the Court of Appeals issued their first decision in a case. It's in Volume 1 of Washington Appellate Reports at page 1, and it was issued on September 10th. That's 2 days after the inaugural ceremony. So I'm assuming they had argument on September 9th and issued their opinion the next day, September 10th.
It was an interesting time because we had to decide, well, what are we going to do? Can we, we're 6 of us in Seattle, can we sit in Spokane sometimes? Can Spokane lawyers, judges sit in Seattle sometimes? We took the position, if it's not prohibited and if it's constitutional, we can do it. So we did do it. We didn't try to rotate through the court initially the full time, but we tried to make sure that the judges over in Spokane got to sit with our division, and that the judges from Tacoma got to sit with us, and then we would sit with them. One of us would go and sit with them, and so we worked out the rules ourselves.
All of the judges in the court had a real sense of mission. That is, they knew this was a new institution, and they took great pride in being members of that institution, but appreciated the task ahead of them, which was to establish the reputation of the court as a credible institution that did fine legal work and had a sense of what the law was, because they were going to be, as you know, the court of last resort for many cases, only a fraction of which would go to the state Supreme Court.
The 3 divisions of the Court of Appeals are cleverly called Division I, Division II, and Division III. Appeals are heard in the division in which the trial court originating the case is situated, but can be transferred to another division if necessary. Division I sits in Seattle and is the smallest of the 3 geographic divisions, though the largest by population. The division includes King County and runs north to the Canadian border, east to the Cascade Mountains, and west to the San Juan Islands. Division II sits in Tacoma. Its territory runs from Pierce County south down to the Oregon border, east to the Cascade Range, and into the peninsula. Division III sits in Spokane and includes 3/5 of the state's land area. All of its territory lies east of the Cascade Mountains. Although each division has a courthouse and headquarters in its largest city, the respective divisions often conduct hearings outside its courthouse and county courthouses or colleges. An anomaly occurs with regard to the Superior Courts of Skamania and Klickitat County, served by one judge.
You know, what's unique about my position is that I have decisions that are decided by two different appellate courts. My Klickitat County decisions are reviewed by Division III, which is over in Spokane, while my Skamania County decisions are reviewed by Division II, which is up in Tacoma. We have a small core group of attorneys that kind of practices in both counties that go back and forth. And so it's kind of unique in that, you know, I'll see them in both counties going back and forth, and that does kind of help with regards to figuring out if you're in Division II or Division III, because that small core group, they know that there's the judges or decisions are reviewed by different courts, and so they'll be very specific sometimes that, well, Division III said this, you know, versus the other attorneys that come in. I don't really see that they even think about that the judge may be in a different division of the court, and I think they feel it's a little more precedential value when they're can say, look, this decision just reached by Division III said this, and I'll see the core group say that a little bit more.
Each division is divided into 3 districts. Judges are elected from the districts. The term for Court of Appeals judges is 6 years. If a judge retires in midterm, the state governor appoints a replacement. The replacement must stand for election to retain his or her seat and complete the rest of the term, usually at the next general election. From its inception, the Court of Appeals has benefited Washington State.
Oh, it's been a real success, and almost immediately, because the establishment of the Court of Appeals took away from the Supreme Court that huge overload that they had. It redistributed the workload, and the most important thing is that people who had problems, judicial problems, had their problems solved more rapidly, which was to the betterment of everyone.
There's no doubt that it made the effect that the Supreme Court wanted. We got a majority of the cases, and the Supreme Court then, I don't mean they retired, they had plenty of work and pretty good, but they got the cases that should go to the Supreme Court. And we handled most of the appeals. And everybody was happy with the system. I don't think anybody was ever unhappy with the State Court of Appeals. So the work got out. Lawyers were happy, I think. At least the feedback we got, they were happy with, because we got through. You didn't have a delay. You got an answer.
If the loser in Superior Court, the trial court, wishes to appeal, the appeal goes to the Washington State Court of Appeals. A party has one right to an appeal. That appeal is to the Court of Appeals, not the Supreme Court. The Court of Appeals must hear all cases appealed to it from the superior courts. The loser in the Court of Appeals may seek review by the Washington State Supreme Court, which sits in Olympia. Unlike the appeal to the Court of Appeals, review is not a right, and the state Supreme Court need not accept the case.
Most people wouldn't realize, but 94% of all the trial cases that come up on appeal end at the Court of Appeals. For most litigants, when an opinion is issued in this court, it's the end. Litigants have a right to ask the Supreme Court to take their case and review it, but it's not a right of appeal like the right to appeal to the Court of Appeals. It's discretionary.
Part of the reason we don't accept very many cases is because the Court of Appeals has done a good job. And even in the cases we have accepted, it's not that they haven't done a good job, but that there might be a need for us to speak in the first instance. There might be a need for a definitive answer.
Sometimes we'll take direct review of a case from the trial court without having it gone through the Court of Appeals. And it typically will involve a constitutional claim or an issue of substantial statewide importance that requires our resolution.
The Supreme Court has the final say as to what constitutes Washington state law.
The Supreme Court takes only about 100 cases a year, And those because there are conflicts between divisions of the court, or because there is a novel issue, or maybe it's one of those few things that was reserved in the Constitution to go directly to the Supreme Court. And so it's the one opportunity for people to appeal to a higher court and say, did I get a fair shake at the trial court? It's a very significant role.
The Washington Court of Appeals hears about 1,500 cases each year.
The Court of Appeals is the workhorse for the appellate courts.
The Court of Appeals is the workhorse of the appellate court system. We're the workhorse. We're just the...
I think the Court of Appeals is the hardest working court in this state. The Court of Appeals, the three divisions of the Court of Appeals, hear the great bulk of appeals from decisions of the Superior Court.
The appellate process begins when the losing party files a notice of appeal. The notice must be filed within 30 days of the final decision of the Superior Court. The losing party is responsible to pay for the clerk's file and the transcript of the trial to be sent from the Superior Court to the Court of Appeals. After the Superior Court record arrives at the Court of Appeals, the losing party files an opening brief. A month later, the winning party files a brief. The losing party then may file a reply brief. The Court of Appeals is much more than its judges. Each Court of Appeals division employs a court administrator who also serves as chief clerk. The clerk's office employs numerous case managers.
The court administrator role is more, I'd say, at a higher level, the overall administration of the division of the court. So it's like the CEO or CAO, Chief Administrative Officer. It involves a myriad of different areas of responsibility: case management, personnel, budgeting, facilities, pretty much anything that needs to be done other than process cases.
The Court of Appeals, like other institutions, endeavors to go paperless.
Over the years, the methodology of moving paper from the Superior Court to the Court of Appeals has changed, and that's been connected with our ability to accept them. In other words, everything used to come in paper, and now today, I would say probably 90 to 95% of the documents that are transmitted from the trial court are transmitted to us electronically.
These updated and modern case management systems will allow the public as well as the courts to have better access to this information and easier access.
Court commissioners also serve each Court of Appeals division.
A court commissioner handles the court's motion docket. There are numerous issues that can arise before the court actually considers the case. Those issues come before the commissioner as motions by the party, and the commissioner decides the motion after reviewing any written memoranda that the parties file on that particular issue, and they also have an opportunity for oral argument.
The Washington State Court of Appeals, Division 3 is now in session. The Honorable Robert E. Lawrence-Berry.
The Court of Appeals does not conduct trials or listen to witnesses. The court reviews the trial transcript from the Superior Court, if there is one, and pleadings filed in the Superior Court.
We like to consider ourselves an error-correcting court, so we don't start from the beginning. We take cases and decisions that have been heard below, and then we review those decisions to make sure that they are legally sound. All of the witnesses have testified below in the Superior Court or sometimes in the District Court, and we get their testimony by way of written transcript. And so we read all of the testimony that they have given, but we don't take original testimony. We don't have a jury box. We don't even have a witness stand.
The Washington Court of Appeals hears every type of case except capital cases, from cases resolving credit card disputes all the way to aggravated murder cases, divorces, real estate disputes, controversies about elections, what should be on the ballot, and anything else you can imagine that someone could ask a Superior Court judge to decide.
During appeals, the Court of Appeals reviews whether the Superior Court made the correct evidentiary rulings.
And sir, at this point, what did Peter say to you?
Objection, hearsay.
Sustained.
At the end of a jury trial, the Superior Court judge instructs the jury as to the law to apply to the case. The appellate court reviews whether the law in the jury instructions was correct.
To instruct you on the law that you are to apply here. I will actually be reading these instructions to you. You can take notes if you wish, but you will be provided with a copy of these instructions in the jury room. Instruction number 1. It is your duty to decide the facts in this case based upon...
A Superior Court judge may dismiss a case before trial or during trial on legal grounds. The appellate court decides whether those dismissals were correct.
There's issues of fact pertaining to the intent of the parties when they engaged in this oral agreement, as we see by the performance of the parties, as well as the statements from the witnesses that are on file here before you today. Those statements contradict each other, and issues of credibility are most definitely more appropriate for a trier to fact. It's for these reasons that we ask that this court deny the motion for summary judgment.
I'm prepared to rule at this time. Mr. Davis, I have to agree with you. There are genuine issues of material fact. The summary judgment motion is denied.
Superior Court judges must make decisions quickly, and therefore many welcome review by the Court of Appeals of their decisions.
I never resented the fact that when I was a Superior Court judge, that a decision I made could be reviewed by an appellate court. I think it's very important that people know that the judges' legal decisions on questions of law primarily are reviewed to make certain that the law is followed.
As a trial court judge, you're kind of doing things at a much quicker pace, making those decisions. So I understand it's very necessary to have those appellate courts go back and look over the decisions as trial court judges are making, which are happening much quicker based upon the size of the dockets and the types of issues that come up before them. And as I was told by different justices and different judges out there, you're really not a real true judge until you've had one of your decisions reviewed and you've been overturned by one of the appellate courts.
If we decide that you didn't get due process on the assessment of fees, and we remand it, do you think we have any role to play in directing the court as to how that should unfold? And
the Washington State Court of Appeals hears a variety of cases.
The Court of Appeals finds the sources for its decisions in the federal Constitution, the state Constitution, federal statutes and administrative regulations, state statutes and administrative regulations, local ordinances and policies, and the common law, both the federal common law, if it's appropriate, and common law generally. First looking to Washington common law, and if there isn't a decision that controls in Washington, to the common law of other jurisdictions, on occasion to the common law of other nations.
The Court of Appeals sits in rotating panels of 3 judges. Cases are assigned randomly to the panels, and one of the panel members is randomly chosen to write the opinion. Each judge has 2 law clerks. One of the author's law clerks reviews the trial record and prepares a pre-hearing memorandum for the 3 panel members.
We occasionally bailiff for oral arguments, but primarily a law clerk reads through the briefs that have been filed for a particular case. We read through the trial court record, and we research the relevant law in the area, and we summarize all of that in a memo that we write for the judges on the panel.
When the briefs of the parties come up at the beginning of each term, the law clerk has the job of taking the first look at the briefs for me, and then first writing a very quick summary of what's involved so I can get an overview of what's coming up in the next 6 weeks, and then writing a more extensive memorandum, we call it a pre-hearing memorandum, that summarizes the arguments that the parties are making, reads the cases that they're relying on, does some additional research to see if there's other things that need to be taken into consideration, and then lays it all out for me and for the other 2 judges who are going to be on the panel deciding the case, so that we have a common basis for discussing the case when we get together before the oral argument is heard.
The Court of Appeals decides most appeals without any oral argument by the attorneys. Periodically, a Court of Appeals division sits to hear oral arguments. The court allows oral argument in the more difficult and complex cases.
In every case, the lawyers argue to us by means of their briefing. And that can be comprised of up to 75 pages for one side of the case and up to 50 pages for the other. And then in some cases, but not all, we hear oral argument where we actually converse back and forth with the lawyers. What that means is that lawyers should not fall into the trap of being prepared to come and deliver a speech to the court. It's much more beneficial to their clients if they start in an organized fashion, but are able to readily pick up from the questions from the court. What is it that the judges are concerned about?
And so if there was a history of walking away from deficits and then all of a sudden you have this turn down in the market and all of a sudden for the first time there are big deficits, it seems to me the history is relevant in looking at, you know, what the parties' expectations were.
Well, I have two tips for lawyers at oral argument. The first one is to listen to the questions asked by the judges and to answer them, not to dodge or reflect away from them. The second is to not recite the facts of the case, but to get to the legal issues in the case, because the judges will have read the briefs and are familiar with the facts.
Please rise.
After oral argument, the three members of the panel discuss the case in a conference.
The leader is usually the judge who is writing the case will lead the discussion. Sometimes cases are of the nature where the decision is relatively easily reached amongst the three judges. Sometimes there's a lot of discussion. For example, if there's one or two judges who disagree. In any case, regardless of whether it's oral argument or no oral argument, the judges will sit all three together, talk about the case, and decide how the decision will come out. And then the person who's assigned that case will write the opinion. Sometimes all three judges agree and it is written as a majority opinion. Sometimes there's a disagreement among the three judges, and so there would be a concurrence where two of the judges would agree and then a dissent written by the judge that disagrees. And we try really hard as a group to come to a consensus where all three agree. Which means a lot of discussion of trying to understand each other's points as to why there's disagreement on what point and how the law. Sometimes we're pulling up cases to try to clarify issues for each other. But there does reach a point where we decide, okay, more discussion will not be beneficial. One person will write a dissent. Sometimes judges agree, but for different reasons. And so sometimes we have a concurrence where two judges agree that this is the right analysis for the case, and then there's another judge that agrees with the outcome, but not how we got there. And so that judge will write a concurrence.
Court of Appeals decisions or opinions may be published first on the internet. If the panel believes the decision has precedential value, it is also published in printed advance sheets issued every 2 weeks and later in bound print volumes.
Precedential would mean that the lower courts need to follow it. The decision of that panel is of precedential value. It certainly controls the case in front of the court, but it also, if published, has value statewide.
I'm in the courtroom every 6 or 7 weeks for 1 or 2 days at a time. The rest of the time I'm sitting at my desk reading and writing.
Almost all time of the appellate judge is spent reading the trial record, reading the case law, writing opinions, and reviewing other judges' draft opinions.
I'm reading everything the attorneys have given me to read, everything my law clerks have thought is worth my knowing, and then I'm reading the works of my comrades, the other judges who send their opinions around. Other judges tend to be in the courtroom most days of the week, and they have much more interaction with lawyers and the public than an appellate court judge will do. We seldom see attorneys, and we even less often see anybody who's not an attorney.
It's a writer's life, really.
Is your job boring?
Oh, it's not boring at all. I wouldn't be here still if I thought it was boring. Although many of the cases follow familiar paths and grooves and go over cases that are well known and arguments that are similar, I'm always surprised to find that there's some idea that a case brings up some new issue that I've really not heard of before or had to explore. Even the familiar ones come up in the context of very interesting facts. I mean, the facts of the cases that we deal with as appeals court judges are really fascinating. I mean, the lives of people and the problems that they get themselves into and the difficulties that people have in trying to get those problems resolved.
Ms. Hernandez has completed her community service.
District court could not be more different from the Court of Appeals. The district courts are literally full of people. I would have arraignment calendars with 96 people, traffic ticket calendars with maybe 70 people on them. The civil cases that arise, generally speaking, people are not represented by lawyers. So the circumstances are very different.
So, Mr. Gorey, your next court date with us, sir, is July 11 at 8:30 a.m.
In the two trial courts, you are literally out front every day, and you're trying your best to deal with people fairly and pleasantly, but there is a certain sameness to day after day sometimes. In the appellate court, it's much different. Our primary place where we work is actually in our chambers, in our offices. That's where we do our research. That's where we do our writing. That's where we conference amongst the judges to determine how we're going to decide a case.
I don't think of this as a 9-to-5 job. I've never been happy in 9-to-5 jobs, so I was happy to discover that this was not one. There are certain days when I have to be here at the court working from 9 to 5. Those are the days when we're actually hearing cases or conferring on cases. But for the most part, I can work at my own pace, and the primary limitation is that I fulfill on time my obligations to write a certain number of opinions that decide the cases. So you know, my first job in my whole life was to be a waitress, and I guess got used to the idea that you can have a rush and then you can rest. And so I like to work really intensively when I'm down here in Seattle. When I'm home in Bellingham, I will work a different kind of a schedule, and I do a lot of reading and writing on the weekends or late at night.
We create and maintain the judges' case files for them. And then we have the draft judges' opinions, which we circulate for comments from the other judges.
One of the things I most value my judicial assistant for is that she herself is a very good writer and very attentive to what the opinion sounds like and how it should be written, and to make sure it doesn't sound like, as one of them said to me once, "Judge, are we mad at this trial, Judge?" to get me to think about the tone that I was using, which I then promptly toned down to be educational and less hostile.
With the consent of the House, the rules be suspended, and substitute Senate Bill 6055 will be returned to second reading for the purpose of amendment.
A judge, unlike a legislator, does not create law and must abide by the statutes enacted by the legislature and rulings of earlier courts.
As a member of the judiciary, you don't get to do what I did in the legislature. You don't reach out and fix problems. You respond to the case that's in front of you. You're basically trying to make sure that the lower court followed the law. You're trying to make sure there's sufficient evidence to support the facts. You're trying to make sure they got it right. The Court of Appeals is a safety net, and that's a role very unlike the legislature, where you get to make policy and create the structure for government.
Mr. President. Conversations about race and racial disparities are really hard to have.
The mindset of a legislator certainly is different from that of a judge, because in the legislature you're representing people. You're trying to achieve what your constituents would want you to do. You're trying to see that their interests are taken into consideration. As a judge, that you're not representing anybody. You're trying to be a fair decision maker regardless of the issue that comes up. And so you may, in a case, have to rule against someone who's presenting the same issue, where if it had been in the legislature, you would have voted for it.
The Court of Appeals is bound to follow state Supreme Court decisions on state law and United States Supreme Court decisions on federal law.
I think every judge comes to a case with a sense of justice and fairness, but what does that mean in each individual sense? And that's where you have to be careful that you're not just deciding a case based on your own particular morals, although that's very important. We have to decide the cases based on the law and the facts before us, taking into consideration all of the circumstances. But we don't just decide the case on a gut feeling.
A Court of Appeals decision can affirm the outcome in the Superior Court, reverse and remand the case for a new trial, or reverse and grant judgment to the losing party at the Superior Court level. Even if the Court of Appeals finds an error in the trial court proceeding, the Court of Appeals may affirm the trial court decision if it determines the error to be harmless. If there is a reversal, the case is usually remanded for a new trial.
The definition of justice may be something a little different for every judge. My definition of justice is the parties have come before court knowing what the rules are, knowing what the law is, with a full expectation that they're going to be heard and that their case is going to be decided according to those rules. That's my idea of justice, and I think that happens here every time. We try to give people a fair hearing. We try to decide their case based on precedent and based on the law. And that way people can depend on us to do the right thing in the case and not worry about their case being decided on a particular judge's personality.
I think of the law, you know, as a fortress. It stays very firm. It's reliable. You know, sometimes mistakes are made and they kind of fall away as time goes on, but on the whole, you know, we're following the law and some really bedrock principles. We follow the bedrock principles that everyone in court is entitled to: a fair hearing, an impartial decision maker. They don't see it as they go about their daily lives, but the fact that you can take your money and put it in the bank and expect to get it out again the next day is the result of judges all over the country being faithful to the law, even if they would like to be sympathetic to somebody. You know, the various systems and institutions that we have won't work if you can't rely on the law.
The profession of being an appellate judge carries anomalies and contradictions. A judge wants to issue a prompt decision, yet reflect before printing an opinion. A judge wishes to be brief, but yet be thorough. A judge wishes to exercise creativity, but also write with clarity. A judge might wish to ignore frivolous arguments from litigants, yet desires each litigant to receive a full hearing and know that he or she has been heard. A judge wishes to collaborate with his or her benchmates, but also wishes to project his or her voice. A judge wants to uphold convictions for crimes committed, but also desires to uphold the accused's constitutional rights, even if upholding those rights may lead to public criticism. A judge wishes to meet justice, but bestow mercy. A judge wishes to stand for principle, but not allow his or her personal bias to dictate his or her judgment. The staff and judges of the Court of Appeals look forward to another 50 years of diligence, integrity, and excellence as we continue to announce and apply the law, administer justice to litigants in the state of Washington, and serve our role as the intermediate appellate court and the workhorse of the Washington State appellate system.
Finally, I want to thank everyone who has worked in the Court of Appeals these last 50 years. The judges, their law clerks, their administrative assistants, the commissioner's office, the interns, the clerk's office. Every person in the Court of Appeals makes a difference every day. We're not able to do our jobs to deliver justice in Washington without the help of everyone. Too often I think people are not thanked for their service, and so I want to thank you very much for all of the service that you have provided to the people of the state of Washington. Happy anniversary.